So the subject matter of this panel is the purpose here is to kind of delve into the issues of regulation and competition and potential changes to the current system that might be pro-competitive. And obviously, a lot of that has already been discussed this morning in the first two panels. So we will try to build on those panels and hopefully not be very repetitive. We have a great panel. I'm going to just briefly mention them all, and then going to do something a little different. Going to ask them each to go for less than 2 minutes or so, and explain how they, their perspective on these issues, how they kind of where they're coming from on these issues, and then I'll start asking some questions. So we have Dale Collins from Shearman and Sterling, and also an adjunct faculty member at the NYU Law School, Lee Knife from DEMA, Richard Masio from Pandora, Tim Quirk from Freeform Development, Brad Prendergast from SoundExchange, and David Wolford, who is a songwriter and producer and the co-founder of the Council of Music Creators and Music Answers, and also a member of the songwriting faculty at NYU. So why don't we just go in alphabetical order and start with Dale?
All right, well, thank you. As Tom mentioned, I teach antitrust law here, and I come at these issues basically from the same perspective, the classical antitrust perspective, okay? And what that really says is that unless there's a market failure, you shouldn't have government intervention on the marketplace. The market should be allowed to operate freely. If there is a market failure, then you might want government regulation if you can demonstrate that the government regulation will actually improve things over what they would be if there was no government regulation. So one of the big questions, if you take this perspective, is what are the types of market failures, okay, that exist in the markets for music rights? And I'm going to give you 2, but I'm going to actually put out 3. Okay, because the first one breaks in. So the first one is a transactions cost. The transactions cost can be so overwhelming that in the first instance, for example, the market just doesn't even develop. I mean, that is the reason why ASCAP formed in the beginning. A special case of high transactions costs are basically the costs associated with information and collecting the information and getting transparency in the system so that the markets can actually work. So those are both transactions costs. The second one, which is interesting because it sort of follows from the first, is to overcome the transactions cost, there was aggregation of the rights, initially in ASCAP. And then ASCAP became so powerful that there was the view that ASCAP had market power. And what really happened with ASCAP to start the 1941 consent decree is there was a fight between ASCAP and the radio stations, and there was what basically was called the ASCAP boycott. And on December 31st, 1940, all the ASCAP music got pulled off the air. The antitrust division sued to solve a market failure. And the market failure here was from the exercise of market power, if you will. There's an argument of whether it was on the broadcaster side or on ASCAP's side. And the solution was a compulsory license through a consent decree. So that's the second market failure, and that is market power through aggregation. So let me leave it at that, and as we go through this, to the extent I'm talking, I'm probably going to bring back all my ideas on what should be regulated and what shouldn't be regulated to those 2 points.
Lee?
My name is Lee Knife. I am the executive director of the Digital Media Association. We are a nonprofit trade organization that represents consumer-facing digital music services, the likes of which are iTunes, Google, YouTube, Pandora, Amazon, Spotify, those types of companies. So to put it very succinctly, our interest is in efficient marketplaces for the licensing of musical works. But there is a delicate balance that has to be struck there when you approach that kind of efficient marketplace, because at least ideally, if not the only way to achieve true efficiency in the licensing of multiple works, indeed large numbers of multiple works, is through collective licensing, like we have either through Harry Fox or through the PROs. And the problem with that is that once you collectivize those rights for the purposes of efficiency of licensing, you have, by definition, created a market distorting potential there, right? You have centralized all of the sellers of a good or a right in one place so that they can effectively, control the pricing of the entire marketplace. And so our interest is in those two things and making sure that we have that proper balance struck. We do see the efficiencies and we do aspire to the efficiencies of collective licensing, but we also are, cautious of the dangers that come with that collective licensing. And for that reason, we think there needs to be some type of regulation. Not sure whether or not it should be in the form of a statutory license or in a consent decree or maybe some other model. But I think, again, what we have to pay attention to is as we scale those marketplaces and as we collectivize those rights and we concentrate the seller side, we have to be careful about how much power we imbue to that seller. And so those are the questions that we have to deal with. Again, I'm not sure I have a specific recommendation as to what we should do, but I think some type of oversight is necessary when you talk about that kind of concentration.
Richard?
So I've been at Pandora for about 6 months. I came over from RDO, where I was there for 5 years working on licensing there. One of the things I'm most proud about at Pandora is how we're connecting artists with our listeners and the unprecedented tools that we have built to do that. There's going to be a lot to talk about up here, but Jim Griffin really inspired me by a lot of what he said in the last talk, and it made me think of the Constitution, which says that the Constitution, it gives Congress the power to promote the progress of science and useful arts for securing, for limited times, to authors and inventors the exclusive right to their respective writings and discoveries. And the Supreme Court later expanded on that in 1975, said the immediate effect of our copyright laws to secure a fair return for an author's creative labor, but the ultimate aim is to stimulate artistic creativity for the general public good. So I think if all people, whether it's music services, authors, publishers, labels, think about each other in that framework, I think we can get to a place where we want to be. And a global database too would be nice.
I'm Brad Prendergast. I work at SoundExchange. In my work there, I work on the Section 114 proceedings in front of the Copyright Royalty Board to set the rates for the statutory license for the performance of sound recordings. I also work on other matters of enforcement, making sure that digital music services are complying with the statutory license if they're relying on it. From that perspective, the things that we focus on, are to make sure that the rates that services pay when they use music are set at a fair rate standard in order to achieve fair market value for creators. And specifically what that means is we want to see a terrestrial performance right in place. We want to see that the rate standard that digital music services have when rates are set under the statutory license is uniform across the board. It should be a fair market value standard, a willing buyer, willing seller standard for all services, instead of some services taking advantage of the 801B factors to realize below market rates. The point of this panel is to talk about ways in which we can create a more competitive market, and competition starts when everybody's playing on a level playing field. And right now, that's not the case among services. It's not the case with respect to terrestrial broadcasting. It's not the case with respect to services that benefit from the 801B standard. We fix those things, we move more toward a competitive market.
My name's Tim Quirk. I started in this business way back in the 80s. I was the front guy in a punk pop band called Too Much Joy. We put out records on indies. We eventually got signed to Warner, spent the 80s and 90s touring and recording for Warner. I got caught up in the dot-com boom in 1999, went to work for Listen.com, helped build Rhapsody, the late lamented Rhapsody, pour one out for them. Helped build that, one of the first on-demand music subscription services. Went to Google in 2010, helped build Google Play. So I've been on that side of the business for a good long time. And in 2014, I left Google to form my own company called Freeform. I won't get into everything we do. I'll just say one thing. It's basically we help artists build apps to control their own free-to-paid conversion funnel. And we're trying to take a different, I mean, what I've been doing all my life is try to get artists, including myself, paid for their actual art. And one of the things Freeform is doing is creating a model that lets artists get paid currently an effective per play rate of about 30 cents a play. So there are better and different ways of doing this. And one thing I'll say, in my time as both a creator and a guy trying to build products that use those creations, the things that have worked best for me on both sides of that are the PRO model. I made more money as a composer through ASCAP and various publishing deals because that money went straight to me and couldn't be crossed by my publisher who I might have assigned my copyrights to, or at least half of that money, and through SoundExchange. I love those models. They work great for the services, and in my experience, they work great for the creators. So that's where I'm coming from.
David?
Hi, I'm David Wolford. I'm a composer and I'm a songwriter, and I'm a co-founder of some advocacy organizations, one of which is called the Council of Music Creators. And we're part of an alliance that regularly communicates with about 500,000 music creators all over the world. So to the extent that I can, I would like to add our perspective to this entire discussion, which is that none of this, you'll forgive me, but none of this is possible or necessary without the creation of music. That if there's no songs and no musical works, there is nothing. So when you're talking about the fluidity and the competitiveness of the business, and then the first panel was touching on the fairness of the business, the key problem for music creators in this entire thing is that there is no one accurately and competently and unencumberedly representing our rights. Our PROs are constrained by the consent decrees and cannot negotiate on our behalf adequately. Our publishers are increasingly non-transparent, are diverting money for their own uses, are hiding advances, are owning royalty stakes in the very services that they're negotiating with on our behalf. So I just ask that everybody at the table take us into consideration. The people that purport to speak for us don't. And I'm not speaking as an individual. I'm speaking as part of a pretty robust collective of people with like-minded ideas. So whatever solutions happen, whatever solutions can be arrived at to the music licensing problem, the creators need to be represented in ways that they're not being represented now. That being said, the creative community is overwhelmingly in favor of collective licensing. We wish it was considerably less encumbered, but we do not see the benefit of direct licensing. In fact, we see to our own perils in it.
Thanks, everybody. Let me get back to, well, I think virtually all of you have touched on this in one way or another, starting with Dale, who identified, the transactions cost issue, and certainly if you look at kind of the history of what's happened in this industry, particularly on the composition rights side, certainly all the explanations start with the issue of transactions costs. It's very hard for all these multiple actors to transact with each other, and so that leads to the aggregation of rights, collective licensing, blanket licensing, all of that. Now, but we're, that's a long time ago, but we still have the system. We now are in the digital age. We are in a world in which millions, probably tens of millions of auctions take place, every day online to sell advertising spots. Kind of a complicated thing, but it happens, almost invisibly, almost effortlessly. So I guess the question that I would have for everybody in the panel is, shouldn't this industry be taking advantage of all the digital technologies that are available? And if so, how could you move away from how could you kind of do that, basically? Anybody want to tackle that?
Well, I'll take a little shot at it. So I think there's two things, right? So one thing you can do is you can lower some of the costs, which I think is happening. I mean, I'm not an expert in this by any stretch of the imagination, but I do have clients in the field, and this is what I understand from them, that to the extent that there's more information that's being enabled because of basically the digital technologies, you can significantly lower costs on things like monitoring. Right? I mean, one of the big costs, right? One of the reasons why ASCAP existed or was created in the mid-teens, 1914, 1915, whatever it was to basically not only be able to, they did lots of things. I mean, one of the things they did was they were able to enforce, well, the first thing they were able to do was able to monitor. If you were a songwriter and you wanted to, and you had a copyright, because the copyright law was amended to give you basically a performance right, to enforce that performance right, you had to find out who was playing your song. And if it's just you, and you got to go to a lot of bars and restaurants and stay there for a long time before you hear the first time your song's being played. But if you aggregate all this stuff, then you could have one agent go in that's got a whole big list of songs, which is the ASCAP repertory, and they could monitor it. So that's one. But if you stress that out to the other end of the spectrum, there's several things in between. After you get a license, then you need to monitor what's being played, if you're a PRO, for example, in order to figure out how you're going to distribute the shares of the music, by whatever formula the PRO happens to use. You still have to monitor it. You could do it by sampling. That's got all sorts of problems associated with it. It's basically how accurate it is, particularly for the songs that are not being played that much. But if you now have digital services, they can give you just the entire playlist. I mean, they can give you everything that's played, and how many times it was played during a certain time period. And you don't have any sampling, right? You've got the complete list. So I think those things are happening. Another thing that you can have when you have these...
Does this all depend on what the last panel was talking about, the creation of some sort of...
Well, this one really doesn't that much, right? I mean, this just... It becomes the PRO's... I think they have to worry about to take the playlists and translate them down into basically what the underlying compositions are, and then distribute the money. But the other thing that digitalization, or at least the creation of digital services, has enabled, is that there aren't that many of them, right? And it turns out, for good or for bad, there aren't that many publishers, for example. I'll just keep this in the publishing world, which is the one I know the most. And so you could have a situation, if you thought that this was a healthy thing to do, and under my perspective, it is a healthy thing to do, and that is to allow the publisher to withdraw their digital rights and negotiate separately with the various digital rights users. I think there are a lot of advantages as far as price transparency, price, basically formation and transparency is concerned. But you couldn't have done that before, the digital services, developed. So that's one thing.
Pandora, I think the one thing we want is we don't want piecemeal legislation. We want technology-neutral solutions, and we want comprehensive copyright reform. And whether that's consent decrees, 115, 114 reform, Lee is working on a lot of that stuff. We've shown that we're willing and need to abide by the standards that we need to, whether it's, for our performance licenses, for, our sound recording licenses with the CRB. So I want to make sure that, I got that out.
But just along, everybody...
Because I think he was focusing in on one area.
But I was going to ask about Pandora. You all seem to be increasingly, and correct me if I'm wrong, bypassing the collective licensing mechanisms and not using them and just doing direct licensing.
Well, it's not bypassing. I mean, we're going towards, a direct licensing regime because of, the way our product is evolving. We won't be able to do some of the features that we are designing under a compulsory license, at least on the, on the non-interactive radio side. We're also building an on-demand service, which then brings us into yet like another set of licenses, which is the willing buyer, willing seller for the sound recordings for on-demand and the performance that's covered by the PROs.
So you would not be interested in doing that on the composition rights side, or have you, I mean, more direct negotiations?
I think we just want to see whatever legislation comes up. We're willing to take a look at whatever it is, and I think we've shown that we're kind of, willing and able to operate under, whatever regime we have to. We just, again, technology neutral and fair, not just to us, but to authors and to labels and publishers. I think everybody has to feel like they've won something, and I think that's what our ASCAP and BMI deals that we concluded in December did, that, we've dramatically increased the remuneration to publishers from like 12 to 1, sound recording to publisher rights to about 5 to 1. We closed the gap considerably. I think we would be paying $60 million more in publishing revenue this year based on the deals that we concluded at the end of last year with the publishers. So I think we're part of the solution. We're putting more money into the system.
One thing, since you mentioned direct licensing, and I know this isn't specifically what you were saying because you're talking about going to on-demand services, but when I was at Rhapsody, there were times I was testifying before the CRB when they were talking about setting the rate, and a point that gets lost a lot when you're on the creative side, it's very easy to just assume like, oh, the higher the rate, the better. That hasn't actually been my experience in terms of the money actually making its way back to me as a performer or a composer, and it's an important distinction. When there's a statutory rate that's going through SoundExchange, 50% of that is making its way back to the artist, no matter whether they're recouped with their labels or not. And I love that because I actually get that money. But when I was at Rhapsody, what I saw was because we had interactive radio features and DMCA compliant radio features as well. If you set that rate too high, all of a sudden you're incentivizing the labels to go to the services, and I saw this happen, and say, hey, that's the rate. We'll do a direct license with you where you can actually pay less than that rate. And it's better for the label because they're getting 100% of that money instead of 50% of that money. And it's a nuanced thing that as soon as you try to explain that to a songwriter or a performer, their eyes sort of glaze over and they don't recognize that just because more money is being paid out, that doesn't mean the creators are actually getting any more. And many times they wind up getting less. The accounting can be really Byzantine, and it's important to keep that stuff in mind.
Just want to make sure we're not setting up a complete dichotomy between direct licensing on the one hand and statutory licensing on the one hand, because you touch on an important point. At SoundExchange, we want to make sure that, like Tim mentioned, that artists are being paid directly, and by statute, artists receive 50% of the non-interactive royalties. SoundExchange also administers some direct licenses as well. And under those direct licenses, it's usually the same approach, where we're administering the direct license, we're making sure that artists are being paid directly. And so Dr. Rubenfeld in the first panel mentioned this trend of more and more direct licenses being in place with non-interactive services as well as with the interactive services where there's always been direct licenses. This is something that we're seeing more and more. It's something that was a huge factor in the most recent Web 4 CRB proceeding. But just because we're moving to a world of more direct licenses doesn't mean that we have to abandon the principle of artists being paid directly or that artists are receiving the designated share of the royalties. That's something that SoundExchange could administer as well.
Yay.
Well, just on that, I mean, even there was a period starting about for, 18 months or so, beginning in 2012, where there was withdrawal by the publishers from, at least several publishers, from the PROs. And if my recollection serves me correctly, they had administration contracts with the PROs to pay basically the artist's 50% shares were administered through the PROs.
The fly in that ointment, that's true, but the fly in that ointment is that since the direct license deals are covered by non-disclosure agreements. Nobody knows what the actual revenue is. In other words, so a direct license where a publisher can claim, well, I negotiated a higher rate for the music creators, never takes into account all the other money that has changed hands that may or may not be payable to the creative person, which is why direct licensing is a wonderful thing if it can make everybody more money. But the experience so far is that it makes the negotiator more money. It makes the publishers more money, it makes the labels more money, and the PROs are defenseless under the consent decree to do anything about it, so there is nobody, what you said is absolutely true. Just because the rate is higher doesn't mean more money is changing hands. And there are, that's one side of the consideration. The other side of the consideration is, when you're talking about digital, is that we narrowly define the rates. We narrowly define the revenue. We say Pandora is paying X% of its revenue to the creative person. True, and the new deal is much better than the old. But there's a large school of thought that says that the music economy in general is not the Pandoras and it's not the Spotifys, it's everything in the pipeline. In other words, Google, forget about Safe Harbor for a second, but Google is a site where a tremendous amount of advertising and data transactions go on because people are looking for music. I listen to Apple Music, but I pay AT&T for the right to listen to Apple Music. I pay RCN for the right to listen to Spotify or Pandora at home. Those are revenues that are nowhere considered anywhere in the music economy that I think under comprehensive copyright reform, as the copyright report mentions, there are people that are appropriating the value of the creative work that are not paying for it. And I think that's why comprehensive copyright reform is crucial.
Are you holding the microphone because you're...
Oh, yeah, well, I was going to, you touched on something else, which is, this might be a tangent, so bear with me for a second. But transparency is a theme that's going to come up over and over again. And you talked about publishers pulling out of deals and trying to do direct deals with some of these services. So now I'm going to put on my service hat as the Rhapsody Google Music guy. Not that I'm speaking for those companies, this is my personal opinion. But transparency is really important. It was, and it drove me crazy back in 2001 when we were striking those original Rhapsody deals. We did a deal with Universal. We knew what we were getting. They would send us a list of like, here's every song and every album that you just bought, basically. When we did a deal with Harry Fox, and this is potentially the case with a publisher as well, they couldn't tell us what we just bought. Right? There was no actual list of here's all the compositions and here's all the authors and here's all the composers, here's everyone who has to get paid now. That's nuts, right? And that's not by accident, right? And so as we move forward, there's going to have to be more and more openness, more and more sharing. That doesn't necessarily mean every last detail of every single deal is public information. That's a little, that you can't actually operate and negotiate effectively that way. But at a minimum, you have to be able to know if you're buying something from a company that, they can give you a complete list of here's everything you got, rather than say, yes, it's now your responsibility to go figure out who these composers are.
Well, if I could just one thing on that. First of all, I agree with you, okay? And I think my guess is that most of the people in, as far as the publishers and labels are concerned, they're moving in that direction as well. I mean, but it goes back to what Larry was saying in the prior panel about incentives. So there wasn't really much of an incentive before there was an opportunity to withdraw from the PROs to basically put those databases together and make them public. Then there was the opportunity to withdraw, but the databases weren't there. And what happened is Judge Cote, who's the rate court judge for ASCAP, put out an opinion that had a fairly blistering section on it that said that there was a very unfair bargaining advantage when the withdrawn publishers were negotiating with, I think it was Pandora, actually, in her opinion, saying that the bargaining leverage came from the fact that the service couldn't tell what they needed to license, and therefore they couldn't pull the stuff that they didn't license, so they were over a barrel. And she, as I said, she was pretty blistering on that. And as everyone knows, there's a Justice Department review with the consent decrees going on right now, and the Justice Department picked that up. And the next thing you know, Sony ATV has put out a fairly comprehensive list of what they think is a very comprehensive list of what they own and the rights they have in it. Universal does the same. ASCAP beefs up its database enormously. Now, I'm not saying that those are necessarily complete and do everything that everybody wants on a database. They certainly don't, because they don't do the mapping from the sound recordings back into the compositions particularly well. But what happened was there was a reason now that there wasn't before to develop those databases, and lo and behold, within about 18 months, you had databases.
So that blistering section of her opinion was productive.
Well, I think what happened was that at least on the publisher side, I think they all recognized that they were not going to be able to get what they wanted, which was the ability to partially withdraw the digital rights, unless they had a means of informing the music users what they owned and therefore what they were licensing, and what, if the music user wanted to play a particular song, whether or not they had a right that needed to be licensed from them. It just wasn't going to happen unless they had that transparency.
Let me ask kind of pushing a little bit further into this kind of world of potential direct negotiation within the context of a highly regulated world. I mean, how does that all work? I mean, you basically have these rate-making institutions, and you can go around them and do your own negotiations. But then the results of those negotiations then feed back into the regulatory apparatus, because the parties to the regulatory apparatus point to them. This is quote a market rate. So how? I mean, is the whole Can you really break away into a more competitive environment in that type of a world?
Can I just a small point in that, under the consent decrees, I'm sure as everybody knows, market rates are not admissible in rate court.
I mean, what is a market rate in this world?
But no rates are admissible in rate court. You can't make, ASCAP can't, or BMI cannot refer to anybody else's rate for any service during rate court proceedings. So it's actually a closed loop. There's no feedback in that instance. They can't introduce that as evidence. The judge isn't allowed to consider it.
So
Well,
what is it?
if I could jump in on that, I mean, Lee and I were just saying, that's really not true. If you read Judge Coates' decision in the Pandora rate case, and if you read Judge Stan's decision in the Pandora rate case for BMI, both of them are replete with information about what the deals were. As a matter of fact, a large part of what Judge Coates' decision was about was knocking out the rates, basically knocking out the probative value of the rates that Sony and Universal had negotiated. Now, whether you think she got it right or wrong, the point nonetheless remains, she felt it was critical that she looked at them and basically said, for basically reasons like the lack of transparency, because of the lack of the databases, that there was too much market power for those rates to actually represent market rates, and therefore she wasn't going to consider them.
One clarification, I think, where you might have been going with that is there is a limitation in the statute with respect to using the sound recording rates.
Right, in other words, right, I think that's what you were perhaps referring to, was that there's this limitation that the rates that get set, for instance, for SoundExchange
Are not admissible.
are not admissible.
Which is the biggest disparity in
Right,
rates.
which I have to point out is ironic, because that was actually a prohibition that was fought for by the PROs. They asked for it because at the time that the sound recording right was being established, the fear was that the sound recording right would actually be a demonstrably low rate. And they didn't want, they assumed, right, that the sound recording royalty that was going to be established would actually be very, very low. And indeed, the fear was that it would be lower than what were the then prevalent PRO rates. And now, whatever it is, 15 years on, 10 or 15 years on, they realize the error of their ways and would love to be able to look at the SoundExchange rates that are coming out of the webcasting proceedings. And that prohibition's still in the statute.
Before we go to the audience, let me just ask, for my own clarification purposes, maybe if people want to talk a little bit about this, this issue of 100% versus fractional licensing. I mean, I can understand how the different sides have different views about should happen. I have a little more trouble understanding that they disagree so much on what actually is happening, what the status quo is. But would anybody like to try to clarify the situation?
I'll take a shot at it with, I will start by saying I don't actually know because I'm not an ASCAP or a BMI affiliate, but in several of the meetings that I've been at with various people at DOJ and speaking with some of the DOJ back office and front office people that are looking at it, as best I can figure out, what you have is actually a disconnect that seems to be happening at the PRO level. In that, when PROs bring affiliates in, they demand that those affiliates give them 100% licensing rights. If you look at the typical affiliate agreement for ASCAP or BMI, it says if you're going to affiliate with us, regardless of the percentage of ownership in a particular composition you have, you're granting us a full ownership right.
How can they do that if they grant the 100% if they don't have it?
I'm not sure I understand the question. No, well,
We should explain what 100%
yeah.
licensing is.
And that it doesn't apply evenly across terrestrial and
The
and
PRO
digital.
would say that clause is that you give me a full interest in what you control.
Right.
And the Justice Department has read it.
Correct.
And in fact, what they told us is that they consider 100% licensing to be the law, and that it has never been enforced properly.
That's right. That's right. Right, and so that's the disconnect, is that, right, DOJ, and I'm happy to couch it that way, DOJ looks at it as those affiliate agreements require 100% of any even fractionally owned work.
Right.
And then what's happening is on the front end of that deal, ASCAP and BMI are maintaining that they never had those rights, or at least were never marketing them to their their licensees. And so that's at least from the DOJ perspective, that's the disconnect, is that there's not this consistency that on the affiliates, the work's coming into the PRO from the affiliate side, it's not clear that they are allowed to only provide fractional licensing. And so the idea is, well, the fractional licensing is available in the PRO, but it's not being provided. And so the DOJ is having a hard time, wrestling with that.
Well, let me just add, the DOJ is having a hard time wrestling with this. I mean, for a couple of reasons. One, as Lee said, if you take a look at the contracts, and that's both the contracts from basically the publishers, the upstream, if you will, the publishers and the writers down to the PRO, they look like they're granting, these 100% rights, which is the right to basically immunize a music user, a licensee, from a copyright infringement suit from co-owners of the composition. And then when you look at the license agreements from, say, ASCAP down to the music users, those look like those are conveying those rights too. And if anybody wants to look at some language on that, just look at the DOJ's second request for comments in the consent decree proceeding, and they quote a lot of it. All right, so then the question is, well, if that's so clear, how come there's a debate? Okay, and here, the debate's coming, I think, from a couple sources. So one source is if you talk to the music publishers and a lot of the writers, I won't say all the writers, but a lot of the writers, they'll say, well, we never thought we were granting the right to license 100% of the song based on our fractional interest. Now, you could say, well, you just didn't read your contracts. The more sophisticated response to that is there is a doctrine in contract law that basically says that courts will read contracts consistent with the custom and the practice, regardless of what the plain letter of the law, says. So that's that's sort of one point. Second thing is, so what has been the custom and the practice? Well, the custom and the practice seems to be everybody was licensing from basically all the PROs, so you never had an opportunity to test whether or not the license from one PRO was basically covering the co-owned works that were being represented by the other PRO. In other words, you don't see copyright infringement suits being defended on the grounds that I've got an ASCAP license and I've got 50% of that ASCAP represents the 50% ownership in the song. BMI represents the other 50%. I don't need a BMI license because I'm covered. You just don't see this, right? So there's no decisions on this at all. The third thing is when you take a look at the rate court decisions, which I think this is probably as telling as anything. Take a look at what the judges have done in rate court decisions, most recently Judge Coate and Judge Stanton, for respectively ASCAP and BMI over a number of decisions. All of those decisions are being done on fractional basis. So the rate court judges think that the licenses are fractional licenses. Now, they've never been asked the question directly, are they something other than fractional? But they're going to have a problem, I think, if this comes to them, of reconciling what they've done in their last 10 rate court proceedings against what the Justice Department's position is, the license was really 100% licenses. So that's where that's how this debate works out, and you can see it's not simple. If I could add just one more thing on this, just so you see where this is going, or what the complications are. The United States is the only copyright regime that I know of that has this 100% licensing concept. It comes out of the concept in real property law of joint tenants in common. No other jurisdiction has it. So if you go over to Europe and you look at their copyright system, they don't have anything like that. They've got nothing but fractional licenses. Well, ASCAP and BMI are the representatives of a number of European societies that are licensing basically these fractional interests in foreign-owned songs in the United States. And if the Justice Department, and they know the Justice Department is very well aware of this, if the Justice Department has basically an interpretation which says that the PROs can only represent rights, fractional rights that give 100% licenses, they got a huge problem with what they're going to do with the foreign rights they represent. That's number one. And number two, there are a number of licenses, not licenses, copyright arrangements between co-owners where the co-owners agree that they will not license their right, basically, they won't license a 100% right without the consent of the other co-owner. Perfectly recognized in copyright law and in real property law. There's a lot of those out there. There's a real question about how many, but a lot of people say there are a lot. And the Justice Department's view of 100% licensing may mean that those kinds of interests can't be represented in ASCAP or BMI. So the Justice Department, I think, quite frankly, not speaking for them, but this is my outsider's view on it, is sort of between a rock and a hard place. They'd like to have 100% licensing, but on this other stuff, the so-called stranded works, they don't know what to do about it. And they keep saying they're going to make some announcement in the not-too-distant future, but they've been saying that for a long time.
You had asked a question about the feedback loop with direct licenses to the regulatory settings. On the sound recording side, this came up in the Web 4 proceeding, and where direct licenses, for the first time in a webcasting proceeding, were part of the evidence of non-interactive direct licenses, I should say, were part of the evidence that the judges considered in setting the webcasting rates. Up until the Web 4 proceeding, the previous proceedings had really relied on, at least from SoundExchange's perspective, the evidence that we had relied on was the agreements that interactive services had reached with labels, and we used that as a basis for proposing our rates, making adjustments downward to account for the difference in value between non-interactivity and interactivity. But in Web 4, for the first time, there were these direct licenses available with non-interactive services that the judges could consider. And it raises a very interesting legal question, and I think this goes to one of the concerns you have about direct licenses in general. On a couple of the non-interactive services entered into evidence direct licenses that they had done, and these were non-interactive services that could always use the statutory license. In other words, their negotiations with the labels, if those stalled or didn't lead to a deal, the services could simply walk away and continue using the statutory license. The standard in the webcasting proceedings is supposed to be that the judges set rates that a willing buyer and a willing seller would agree to. And when you have a situation where the service is non-interactive and can simply rely on the statutory rate, then you have a situation where the seller isn't necessarily willing. The seller is compelled. It's a compulsory license. Nevertheless, the judges put a lot of weight on, and in fact used these two agreements as the basis for setting the rate for non-subscription services, and to the exclusion of looking at the interactive agreements that we had put into evidence for setting the rates. And it raises the circularity problem that Dr. Rubenfeld mentioned in the first panel, that if the deal set in the shadow of the statutory license set the statutory rate, then that can continue a spiral in a circular feedback loop that would keep the rates artificially low. at least in our view. And so there's an interesting legal question of the extent to what the judges should rely on these deals, these direct deals that have been negotiated in the statutory license, where the seller can't simply walk away from the negotiations and prevent the service from using the content. And also, too, the judges relied on 2 agreements, which is interesting from the standpoint that a lot of deals get negotiated. And we've talked about how many direct licenses are coming along and how that's an ongoing trend, and it's not something that's going to stop now. But if the judges are looking at 2 particular agreements, then there's a real risk that any agreement that a service and a label agree to that might be on an experimental basis might be used as evidence down the line, and that might have a chilling effect on being creative and how these direct licenses are structured. And so that's another interesting consequence of the Web 4 reasoning.
Let me give the audience a chance, if anybody wants a chance. Any questions from the audience? Well, let me ask one final question. I think Chris in the earlier panel said something like, "Is there any way out of this mess?" So that raises 2 questions. One is people's view on whether or not this is a mess, the current system, and then if not, then we don't have to get out of it. But if it is, are there some suggestions about how to get out of it? Is it a mess, first of all?
It's a mess. So.
Yeah, I don't think you're going to find anybody on this panel who's not at least nominally going to say that it's a mess, right? It's just a matter of how big of a mess, you might think it is. I happen to think it's a really big mess. And I think most people would probably agree. As to, what can be done about it or what should be done about it, I think, that depends on actually the view that you have of what you think you can accomplish versus what ought to be accomplished, right? There's a big gap between, what we should be striving for aspirationally versus what we think we could actually get done, going all the way down, excuse me, to, the practicalities of what we could get done in the current political climate, right?
Do you think anything could be done in the current political climate is feasible?
Yeah, I do, because, not that we need to get into whatever Washington politics and stuff, but I think copyright in and of itself presents an interesting area because it's largely, it's a nonpartisan topic to a large extent. And so, my view of it is if you're a congressman and you're looking at the fact that you are, completely stymied by partisan politics and the fact that no one will cross the aisle on, the bigger issues, if you will, or whatever other issues, let's say, because this is a big one. You might look at copyright as a way to actually show your constituency and to, actually move Congress forward on at least some, again, important issues. So I think copyright remains ripe for activity, even in the kind of, again, the kind of stifled political climate that we have. But getting back to answering the original question, again, I think the difference is between what you think you want to strive for as an ultimate, right, as a panacea versus what you think you could actually get done. I think ultimately what we want to do is pretty much almost throw out, at least on the music licensing side, almost everything we have in copyright now, because, and you've seen it throughout this panel and the earlier panels. You've got different rate-setting bodies applying different rate-setting standards for different rights that are exploited sometimes only based on the different media, right? That's just crazy. Someone else said it on one of the panels earlier, and it's often repeated, that it's safe to say that if anybody had to construct a copyright regime today, it wouldn't look anything like what we have now, right? Because it's this odd patchwork quilt of just, special interest rights on top of special interest rights. So I think that's the ultimate goal. But I think in the interim, right, in what's possible, maybe not probable, but at least possible, is there some kind of licensing reform where either, we homogenize the rate-setting process, the rate-setting standards, and as everybody's been talking about here, the big issue is getting a comprehensive database that both rights holders and rights users can point to and say, that is the definitive database. Because I think if you do that, I think it was Jacqueline Charlesworth who said on one of the earlier panels, a really robust, comprehensive, and definitive and authoritative database actually makes a lot of these problems go away, including, you know, the distinctions between statutory deals, statutory rate deals and direct deals and stuff. Because if the database is truly functional and it's efficient, it will lead to direct deals that have many of the trappings of a statutory deal. They'll be transparent, they will be routine, they will be efficiently arrived at.
Will at least 50% of it go directly to the creators? That's my own, literally, as a performer and a composer, that's my only question about anything. Like, I don't care what the rate is,
Right.
because if it's not coming directly to me, the rate is meaningless to me because I'm not going to get any money.
The report of the Copyright Office, the comprehensive report, I think is a great starting place as a blueprint. It acknowledges the rights of creators. It acknowledges the rights of the services. Everybody gives up something. Everybody gains something. It's, for those of you who haven't read it, I hope you all have read it, but it's as good an analysis of the contemporary music business as exists. And it's thorough. The fact that Washington as a unit is not saying, well, hey, look at this, we got this. We can just start working on this now, to me is virtually beyond comprehension. It's a starting point for an entire blowing up of the system and putting it back together in an intelligent way, and I think a fair way for everybody.
Anybody else before we close up? Well, thank you. Thanks to the panel, and thank you all for coming.
So on behalf of the Engelberg Center, I want to thank first Tom Lenard and the Technology Policy Institute, which has been our partner on this program. We very much appreciate the discussions we've had and the learning that's come about from that partnership. I also want to thank the speakers on our 3 panels. I have to tell you, when I started trying to work to pull this panel together, I was still kind of naive in terms of my learning about the music licensing world. And as I started to get into it, I realized how complicated and difficult it was and what a challenge it might be to have really substantive, reasonable discussions. So I give each of the speakers on the 3 panels a tremendous amount of credit, because we've achieved the kind of discussion we wanted: substantive, reasonable, and something I think that will help move things forward in the future. So please join me in giving all the panelists another hand.
Yeah.
And lastly, I have to say, I want to thank, and you should all, if she's still there, give a shout out to Nicole Artz, one of the 2 people at the registration table. She's the Engelberg Center project coordinator, and she just masters the details. So we really appreciate her help today. Thank you all for coming. If you have comments on the program or any of the subjects, please feel free to call, reach out to me by email. I'll get them to the right people. And I also think it will help us as we develop our thinking about how to do something productive in developing some policy recommendations for this industry. Thanks again.
Thank you. It was a lot of fun.
Thank you.
Yeah.